Proceed, Mr. MacIver.
One of my first assignments after becoming an organizer was J.P. Stevens. I was responsible for a good many of those workers being discharged and possibly having a plant closed down simply because I told those workers they had the right to join and support the union. I can remember 3 man and wife combinations whom I personally talked into putting on a union button and passing out leaflets, who were subsequently discharged, firing the husband on one Monday and the wife the next Monday. I was out in the field in Statesboro, Georgia, as the organizer in charge of that particular campaign, when not only the management was telling the workers that they were going to close down, but everybody in town, including state legislators, were telling the people that the plant would be closed down should the union go in. The plant was subsequently closed down after the union obtained bargaining rights. I'm a Korean veteran. I believe in the system in this country. I always have. I always will. I think it is the best country in the world. But I find it more and more difficult to get up in front of a group of workers and tell them, brother and sister, you have a right to join the union. The federal law says you have the right. I am afraid we are getting to the point where the act protects the employer more than it protects the employee.
That's an American talking. He is shocked, and with good reason, that in the world's longest living democracy, in the 1970s, millions of his countrymen, American workers, are still denied their basic human rights. He is appalled that human rights should still be an issue at all. Okay, he's saying, I can understand the need to defend the human rights of oppressed people in other countries. But in America, that's a hard pill to swallow. In 1935, Congress declared an end to the long and often violent war on unions. It passed the National Labor Relations Act, also known as the Wagner Act, which declared it is the policy of the United States to encourage the practice and procedure of collective bargaining by protecting the exercise by workers of full freedom of association, self-organization, and designation of representatives of their own choosing for the purpose of negotiating the terms and conditions of their employment or other mutual aid or protection. The Wagner Act was intended to mark the beginning of a new era of labor relations, an orderly and peaceful era free of industrial strife, an era guided by the rule of law, not the whims of men. Above all, a progressive era of worker freedom and dignity through union organization and representation. But 42 years into this era, there are still enormous pockets of resistance. There are still countless holdouts who refuse to accept the fact that the war against unionism is really over. Like the old soldiers in a different kind of war, they refuse to put down their sabers and die quietly. Unlike those soldiers, they won't even fade away. And why should they? They're getting away with murder every day. They're brazenly evading, defying, and destroying the law, and ruthlessly denying the freedoms of millions of American workers, just as though the Wagner Act had never existed. Who are these die-hard soldiers in this obsolete war? Companies, both big and small, located in all parts of the country, engaged in a wide variety of labor-intensive industries, such as textiles, mining, auto parts, chemicals, and steel. Union-busting firms able to hire the best professional help money can buy to do their dirty work. Smart, stylish lawyers and other consultants armed with attaché cases and legal briefs. the successors of those roughly dressed thugs from another era who used guns and truncheons to do the same job, though not as effectively. And who are the victims? Largely low-paid workers who discovered one day that they had legal rights to organize themselves for decent pay and benefits and working conditions, who set out to establish those rights for themselves by openly declaring their desire to be represented by a union, and who soon learned that the price for their freedom to organize was exceedingly steep. Pressure, harassment, possible physical injury, almost certain loss of their jobs, industry and area-wide blacklisting, and a long, desperate period of unemployment. What price freedom? What price human rights? When the House Subcommittee on Labor Management Relations asked Maureen Hedgepath of Roanoke Rapids, North Carolina, to answer those questions in late 1976, she began this way.
I went to work at the Rosemary plant of the J.P. Stevens Company as a weaver in 1956. My mother and father also worked for the Stevens Company, and my husband and a brother. The mill has been part of my life from my beginning. I became active in the union in 1963. I attended a meeting in Charlotte, and after the meeting, we sent a copy of the names of people that were involved in the union to the company.
Times are getting hard, boys. Money's getting scarce. If times don't get much better, boys, I'm bound to leave this place.
With that simple act, that simple exercise of her legal rights, Maureen Hedgepath set out on a treacherous and heart-rending journey that millions have set out on before and since. The House Subcommittee on Labor Management Relations asked Maureen and several others to tell their stories. If it had asked those millions of others, it would have heard very similar tales. The depressingly monotonous experiences of a downtrodden minority, a composite picture of injustice in modern American industry. A worker at a Northeast manufacturing plant declares her desire to join a union and finds herself tracked every minute of the day and frozen off from her fellow workers. She can't leave a work area, go to the canteen for a soft drink, or even go to the bathroom without the foreman banging on the door and telling her to get out and go back to her job.
They won't let me talk to anyone because they know I'm for the union, and they don't want to have me convince anybody that the union is the right way.
A worker at a Midwestern auto parts plant agrees reluctantly to testify at a National Labor Relations Board hearing about the harassment he has suffered since announcing his support of the union. He repeatedly implores his NLRB attorney not to make him testify. He explains that the company would find some phony work-related excuse to fire him. The lawyer confidently assures the worker that the company could never get away with such an obvious act. So the worker testifies and, just as he predicted, is fired the following week on the day before Christmas. The grounds for dismissal? The appearance of intoxication. At a Western electronics plant, a group of veteran workers complains about the trumped-up dismissal of a fellow worker for his unionist activities. They, too, are dismissed. A southern textile company threatens to close a plant if it becomes organized. So the workers get scared and start to shun the members of the in-plant organizing committee. Eventually, the organizing drive collapses. At another plant, the company makes a threat. The workers proceed with their drive, elect the union as their bargaining representative, and the company makes good on its threat, throwing several hundred employees out of work. Several Southern steel workers, members of an in-plant organizing committee, lose their jobs as a result of their union activities and find they are unable to find work anywhere. They are blacklisted throughout their area and throughout their industry. First, they get on the unemployment rolls, and then the welfare rolls, where they remain for many years until they either move or die or change their names or get lucky and win a long battle for reinstatement. Another worker returns to her job after 6 years by order of the NLRB and is treated like an outcast by co-workers fearful of becoming guilty by association. Speaking to the House Subcommittee on Labor Management Relations, she said,
When I went back into the plant, the people said I couldn't stay. I said the law says I can stay if I can do the job.
the law was on her side, and it still is, for her and for millions of her fellow workers in an array of companies around the country. But those companies have discovered that flouting the law is a profitable enterprise, much more profitable than obeying it. They have discovered a winning formula for making the law work for them. Chairman Frank Thompson of the Congressional Committee on Labor Management Relations explains.
The employees turn to a union, and the employer discharges the leaders of the union, or sometimes openly frightens others from union activity. And then the employer invokes that to which he's entitled, due process, and thereby delays 2 or 3 years. At the end, he has to offer reinstatement if he can find the discharged employees with back pay, less what they earned or should have earned elsewhere. Then, in J.P. Stevens and Winn-Dixie and other companies, it's perfectly obvious they repeat the same formula in another plant. The employer loses every battle, but in the end wins the war. He buys time. He frightens the union organization. And then he makes his back pay awards. And he, of course, uses counsel, very sophisticated counsel. He pays tremendous legal fees and deducts them as a cost of doing business. And although there's a pattern in some industries, at least of an increase in hourly wages, a slight increase, all of the evidence seems to indicate that if the unions were to succeed, the hourly rates would be higher than they are now. Let's say 30,000 employees, and you're saving 5 or 6 cents an employee per hour every day. Well, you can afford any number of $1,000 contempt fines or any number of lawyers.
Companies all over the country use this formula to defy the law. J.P. Stevens has used it with such success that despite its defeats in numerous major NLRB cases over a decade, despite the upholding of many of those defeats in federal appeals courts, 3 of them in the U.S. Supreme Court, there is still, to this day, not a single collective bargaining agreement in a single Stevens plant. No other company has achieved such a dazzling record of anti-unionism and successful defiance of the law. No other company has inspired a score of judges to soaring heights of eloquence. One judge, Boyd Leadham, former chairman of the National Labor Relations Board, wrote,
J.P. Stevens is so out of tune with a humane, civilized approach to industrial relations that it should shock even those least sensitive to honor, justice, and decent treatment.
J.P. Stevens is the pace setter, the pioneer, the superstar of anti-union practices. But it is by no means alone. It has plenty of company, plenty of blue-chip company at that. Litton Industries, a multi-industry conglomerate with over 100,000 employees, has been the object since 1963 of 29 separate NLRB cases involving its harassment and dismissal of union organizers, its refusal to bargain in the event of a union victory, its attempts to undermine established unions in companies it absorbs, and its violation of informal agreements with the NLRB. Dow Chemical, another blue-chip giant, has been on an anti-union spree since a 1969 change in its top management. It has pursued several creative variations of the standard formula, such as contracting out to non-union companies unit work its own employees should be doing, clogging the grievance and arbitration procedure by contesting each charge to ridiculous extremes, and illegally initiating and financing a series of decertification elections. The Florida Steel Corporation has fought organizing campaigns at 4 of its 11 plants with the traditional formula tactics, as well as some racist tactics to divide and conquer the workers. The NLRB has found the company guilty in 9 separate cases. The Monroe Auto Equipment Company, which escaped from the Union heartland of Detroit to the anti-union bastions of the South and Midwest and rural Ontario in the early 1960s, has compiled a notorious record of union busting, one that has involved force and violence, intimidation, worker discharges, community pressure, and since certification in 1966, one delay and evasion after another despite a succession of judicial defeats. The Monroe workers are still without a contract. These are stark violations of human rights right here in America, and the list goes on and on. One company after another relentlessly trying to beat down every employee attempt to legally establish a union. There is only one thing this otherwise motley array of companies has in common: an utter disrespect for a landmark law of the land and the human rights of their employees. This disrespect has yielded high dividends, not just immediate dollars and cents dividends, but the long-term dividends reaped from the disillusionment of millions of workers with a law they can no longer believe in. Thousands of working men and women have embarked on a concerted, wide-ranging campaign to restore belief in a law that was meant to serve them, indeed that was once hailed as the Magna Carta of labor. The goal is not to tear up the law, but to reform it, to endow its legally authorized enforcers with sharper teeth, quicker reflexes, and a sleeker figure, to, above all, restore a measure of equity for labor that has been largely destroyed in the 42 years since the Wagner Act's inception. In designing a reform program, we've decided to go to the twin roots of the problem. 2 amendments, the Taft-Hartley in 1947 and Landrum-Griffin in 1959, that were passed ostensibly to correct a so-called imbalance in favor of labor, but which established a gross imbalance in the opposite direction and gave the anti-union elements in this country a convenient handle on which to hang their discriminatory and repressive acts. As AFL-CIO President George Meany said in a recent address,
"There is no balance, no fairness, no even-handed justice today in the National Labor Relations Act. Today, an employer can violate the rights of his employees to form their own unions, virtually without fear of punishment. The few penalties are so weak that employers are saying to hell with the law."
Toward that end, America's workers are going to Congress this year with a long list of grievances and with a list of recommendations for new and just legislation to redress those grievances, for human rights for American workers. The legislation would restore the National Labor Relations Board's power to hold representation elections without any delay in cases where there are no major legal issues involved, require the board to hold such elections within 15 days, and require the board to hold elections in more complicated cases in 45 to 75 days. Give unions the same rights as employers to swift handling of unfair labor practice charges and to the use of the preliminary injunction to stop alleged wrongdoing during the time full legal proceedings are underway. These rights are necessary to properly correct discrimination against workers who exercise their right to organize and to prevent illegal refusals to bargain after elections. Deny government contracts to employers who willfully violate NLRB orders entered to protect workers, just as though they violated laws against discrimination based on race, creed, color, national origin, or sex. Streamline the NLRB procedures. Provide for a procedure to permit the board to swiftly affirm some administrative law judge opinions. Permit the board to issue self-enforcing orders, and increase the board's membership from 5 to 7. The result would be a lighter caseload and more rapid and fair dispensation of justice. In brief, that is our program. We believe it is a reasonable program to right wrongs, eliminate inequities, and restore the spirit and the substance of a 1935 Act to the labor relations of the 1970s and 80s and beyond. As we press forward with this campaign, Congress is proceeding with a bill to reform the labor law system. It's a good bill because it will give the American workers the human rights they so richly deserve. Therefore, if we are to get all the improvements we need, it is up to you to back up your legislative representatives in Washington, to tell your congressmen and senators what this program is all about and why it is so necessary. With your support, the day won't be far off when a union representative can go before a group of workers and tell them, "Brother and sister, you have a right to join the union." On that day, the war will be over, and we'll have reform at last.